said a few days ago in his comment called judicial corruption and judicial impunity. I think as a country we must have this conversation because what we are seeing in this country is judicial impunity, and we are having judiciary that has gone wrong. While we respect the principle of independence of judiciary and principle of separation of powers, we always think as parliament that judiciary normally oversteps their mandate, because the work of judiciary is to interpret the law. The work of the executive is to implement, and the work of parliament is to legislate and lawmaking process. What we are seeing as a country is where there is what we call overreach and overstating of their mandate. I think judiciary must be called to order. I said last year that the current judiciary we have has gone wrong. While we appreciate that the rule of law and judicial independence should be respected, that one does not extend to judicial impunity and corruption. We are in a country now at the moment that Kenyans are saying, why hire a lawyer if you can pay a judge? And that is the we don't want to see. And that is why in 2003, the former President Kibaki said that there were radical judicial reforms. We don't want to live in a country where justice is being sold to the highest bidder, where court orders are issued at the expense, or court orders are just being issued at the expense and at convenience of people to do who can buy. The court orders we are seeing nowadays are being issued easily more than even tissue papers, and therefore it is very unfortunate. We want to call upon the Chief Justice, who is the chairperson of the Judicial Service Commission, to bring this judiciary into order. Where we, in fact, as we talk now, we must even do inquiry into state capture of judiciary, because we have seen cases where judiciary issues decisions and court orders that even does not make sense. How can you issue a court order against cutting down of NHIF to 300 shillings to every Kenyan? I thought these judges and judicial officers are family and relatives and their children and even their parents who are in the village, who cannot afford to pay 300 shillings, who cannot pay 500 shillings in NHIF. The president was proposing that NHIF cover the Kenyans who do not have job should be given opportunity to pay 300. How can you explain a court decision that says that don't pay 300 shillings for every Kenyan to access universal health coverage? Even on the affordable housing, are they aware more than 4 million Kenyans live in deplorable slum conditions in Nairobi, in Kisumu and other major cities? We're having even rural slum in some of the counties that we have in this country. The president has come up with a program of affordable housing where Kenyans, and one of the basic human rights is decent housing, food and clothing. The president is proposing to fix the issue of affordable housing. Why would somebody where 4 million Kenyans live in dilapidated conditions, when it rains they get pneumonia and diseases, why would somebody who is a Kenyan and who is a guy sit and issue an order against developing affordable housing in the country? I think, as the president said, we must have a conversation as Kenyans, because while we respect the principle of separation of powers, while we respect the rule of law, I think some of the court decisions and court orders that are being issued does not make sense. And judiciary should be aware they are not immune to criticism. The people daily criticize parliament and even executive. Why is it when we criticize judiciary for the wrong and the court orders that are being issued that does not make sense or not even anchored in morality or law, the people who are quick to say they cannot be questioned is judiciary, the Law Society of Kenya, the Senior Bar Council. While we appreciate their concerns, they should assist us in fighting corruption in judiciary, because corruption is not only found in other areas but also in judiciary. And therefore, the president, as a Kenyan, as a leader of this country, was within his right. Number two, under Article 159, judicial authority is derived from the people. Article 160 the same. And they must exercise judicial authority in the principality of neutrality, in the principality of rule of law, and the constitution. So judiciary does not exist in isolation. They derive their authority from the people under Article 159 of the Constitution. And therefore, as a country, we must even think where in other jurisdictions where judges are voted to office. It is a high time as we have this conversation. Judges and judicial officers must be voted to office, because in other jurisdictions like America, even the attorney generals of states are being voted for the offices, so that when they exercise power, they exercise on the behalf of the people. Number two, judiciary should tell us and courts whether they want to legislate and do lawmaking. They have encroached the power of the parliament of legislating and lawmaking. They have encroached the power of implementation of the executive, yet their job is to interpret the law. They are not supposed to legislate or lawmaking. Lawmaking, if they want to legislate and lawmake, let them run for offices, be elected, then they can come and legislate in parliament. They should allow the principle of separation of powers, respect even the laws that we pass on universal health coverage, or even affordable housing, on issue of housing levy fund. Under Article 118 as Parliament, we sat and did a public participation. We followed the legislative process until it was made into the law. Why is it now they are calling it illegal and unconstitutional? Yet we undertook the entire process, including public participation. Imagine another judge the other day issued a court order against doing public participation. And yet public participation is a constitutional matter. How can you issue a court order against the public participation, yet public participation is anchored under principles of good governance, Article 10, and under Article 118 on legislative process? So judiciary must be called to order. They are not immune to constructive, and I want to assure the nation, the manifesto, the President William Ruto was elected based on the manifesto that is sold into Kenyans. We cannot allow judiciary to get on the way through senseless, immoral, illegal, and unconstitutional court orders that prevent the president from implementing his manifesto that is sold to Kenyans. And therefore, I want to ask Judicial Service Commission, and that is why we must have a conversation of even judicial ombudsman, because the chairperson of Judicial Service Commission is CJ Madam Kome. Yet we are telling her to fight corruption. I think it is high time we must have an independent body to check on the excesses of judiciary. Just the way other bodies are being checked. They are not immune, they are not next to God, they must be checked as per the constitution. Kitu ambaye nataka niseme hivi, vile rais amesema, tunashangazwa sana na mahakama zetu, ikawa tunaheshimu sheria. Ile court order ambazo zinatolewa zinashangaza kila Mkenya. Kwa sababu rais alileta sheria, tukapitisha kule bunge, tukasema kila Mkenya kuanzia tarehe 1 mwezi huu atakuwa akilipa shilingi 300. Wengine wakora wakaenda kotini, wakachukua court order, wakasema wala Wakenya wa chini wasilipe NHIF ya shilingi 300. Kidogo kidogo zaidi ya Wakenya milioni 4 wanaishi katika manyumba zile zinaitwa slums hapa Nairobi na sehemu zingine za taifa, zile town zetu. Rais akasema hako na affordable housing, mashamba zimepatikana, Wakenya wajengewe nyumba kulingana na mshiko za haki za kibinadamu. Kwa sababu haki za kibinadamu moja wapo ni nyumba mzuri, ya pili ni malazi, na ya tatu ni mambo ya chakula. Rais akasema tufanye ile kitu inaitwa affordable housing, ndio kila Mkenya apate nafasi bora ya kuishi nyumba ambaye ni ya heshima na wasishikwe na magonjwa kama pneumonia na zile zingine. Wale mikora tena wakaelekea mahakamani, wakafanya ukora na ufisadi kule mahakamani, wakapata court order. Mimi nataka niulize mahakama, isikuwe ya kwamba wanafanya siasa na maisha ya Wakenya. Mahakama sasa ya Kenya imekaa ni kama imekuwa extension ya Azimio na wale mikora ambao wanaelekea mahakamani. Kwa sababu hata unaona hata tuliwashinda kule maandamano, tukawashinda, wakatoroka, wakaacha kuvaa masufuria. Sasa wameenda kupiga kambi kotini, wanatumia ufisadi na ukora, na tunajua hii mambo yote ni Azimio na aliyekuwa Rais Uhuru Kenyatta wameketi mahali wakasema kwa sababu hii William Ruto atabadilisha maisha ya Wakenya na ataendeleza uchumi wa Kenya, ile tutamtega yeye tuende kotini. Wakafika kotini, wakapata majaji ambao ni wafisadi, wakachukua hata court order ambayo inapatikana ovyo ovyo kuliko zile tissue papers. So sisi tunamuuliza kiongozi wa mahakama, ingawa tunaheshimu principle of separation of powers, mahakama lazima iamue kazi yao kulingana kikatiba ni nini. Kazi ya mahakama ya kulingana kikatiba, kazi yao kubwa sana ni moja, kuinterpret the law. Kazi ya bunge ni kutengeneza sheria. Kazi ya executive ni kuimplement ile maendeleo ya Wakenya. Sasa tunapata mahakama ya Kenya inataka kufanya kazi zote, inataka kuimplement ile kazi ya executive, inataka kutengeneza sheria na kurekebisha ile kazi ya bunge, inataka kuinterpret ile kazi. Sisi tunamwambia mahakama na wasijifanye mahakama pia kama ile bunge, kama executive, lazima wakuwe tayari pia wakuwe criticize, wakuwe constructive criticism against them, ndio wasikuje wakasema ya kwamba ati hawa ni sheria. They cannot allow. Na hiyo kitu ambaye ni muhimu sasa, ambaye Wakenya tunatakana tujue ya kwamba lazima hii mambo ya state capture, kwa sababu judiciary imekuwa captured na cartels na wafisadi. Na nilisema mwaka jana mwezi wa 3 wakati niliongea katika runinga moja hapa Kenya, nikasema hii mahakama imeshikwa, imekuwa ile inaitwa rogue, na ingawa wanatakana kulingana na article 159 ya katiba ya Kenya 2010, ile uwezo na nguvu ya mahakama ya kisheria ya kikatiba inatoka kwa wananchi. Na sisi kama taifa lazima tuongee tunapoenda mbele. Wale watu wanataka kuwa majaji lazima wapigiwe kura kama nchi zingine, kwa sababu ukienda zile zinji ambazo zimeendelea, kama unataka kuwa judge, kama unataka kuwa attorney general, lazima upigiwe kura ya mwisho. Tunajua kuna mpango fiche. Wakati hao walienda maandamano tukawashinda, wale wapinzani wetu wa kisiasa wameenda kupiga kambi kule mahakamani, kwa sababu wanataka kusimamisha ile agenda ya rais, kwa sababu rais anataka kujenga manyumba kwa Wakenya ambao tunajua 4 million hawana nyumba mzuri plus. Tunataka Wakenya walipe ni mambo ya NHIF shilingi 300 ndio wapate matibabu kutoka mashinani na katika mahospitali zetu. Sasa hii mahakama wanasema wazilipe, kwa sababu hii nashangaza, hao majaji na hii mahakama si wa Kenya. Kwa sababu ningekuwa nafikiri mahakama hata ingefikiria ya kwamba kwa sababu wa Kenya watalipa shilingi 300, hata hawangetoa hiyo order. Na hii sheria ambazo wanasema ni unconstitutional tulipitia kama mbunge na kama senator, tuliketi tukasikiza public participation under article 118. Na kitu ambayo inashangaza, hata unajua tunashangaa hii majaji wanaenda shule sheria ya nchi gani, kwa sababu hata judge moja anasimamisha public participation, na public participation ni haki ya kikatiba kulingana na 118. Na mimi nataka niunge mkono rais, ile court orders ambaye si make sense awachane naye, hizo zitumike kama tissue paper, tutupe huko kando, kwa sababu hatuwezi kuwa nje ya kusimamisha. Sasa hii Wakenya wanataka manyumba, Wakenya wanataka mambo ya mabarabara, Wakenya wanataka mambo ya matibabu. Rais, sisi tunakuambia kama viongozi, na sisi tunaongea kwa niaba ya raia, kwa sababu tulichaguliwa. Nikiongea hivi raia wameongea. Tunamwambia rais, kama kuna court orders zitasimamisha mpango ya manifesto ya serikali yako, you ignore them, because we must be deliberate. Asa hizi inchi zingine kama wakapata maendeleo ndio wakakuwa fast. I want to ask the president, if there are many court orders that not make sense, the president should ignore them for the benefit of Kenyans, because we need to fix this nation. We need affordable housing. It's a concerted effort by the people we defeated the president, and we are saying it is a high time that judicial inquiry into the state capture of judiciary must be open as soon as practicable possible. Na mimi tukirudi bunge mwezi wa pili, mimi nitasponsor motion ya kuset up state capture investigation into judicial inquiry and into judicial ineptitude and corruption and moribund that is within the judiciary. And we must also, as a Greek nation, lazima tuunde kitu ama tume ya kuangalia ile lazima tuunde tume ya kuangalia ile excesses, kwa sababu hii judiciary imekuwa kama Mungu. Tukiuliza kitu wanasema tunataka kuangamiza judiciary. Mbona hao wanaulizanga bunge kila siku, wanalima bunge hatuna shida, wanauliza rais maswali hatuna shida? Mbona judiciary ikiulizwa shida wanapiga kelele? Na mimi hata naona walikuwa na ile budget. Tunajua mimi nimewahi kuwa mwenyekiti wa mambo ya sheria kule bunge ya Senate. Mimi tulitetea judiciary waongezewe pesa. Rais William Ruto, hii judiciary ilikuwa inapata 19 billion. Sasa hii tumechukua judiciary mpaka 23 billion. So how can we fight judiciary when we give them more resources? Na wanatumia hiyo resources kupiga serikali. Hapana. Uwezi ile mkono imekupea chakula. Hiyo ni lahana. Uwezi pewa chakula na hii mkono alafu inauma, na hiyo ndio judiciary wanafanya. You cannot buy the hand that gives you what you eat. We give judiciary through the executive resources, and then they go ahead and use the same resources to fight government. Hiyo mikono munauma hakuna siku mtapata hiyo kitu ya kuuma tena. So asanteni sana, Mungu awabariki, na sisi tunamwambia rais aendelee, asisumbuliwe. Sisi tutadili na hawa, tumejua hii judiciary na Azimio na Uhuru Kenyatta ni moja. Hata tunajua mandugu zake na madada wako huko, tunaangalia na 18, lakini tunamwambia rais tuang'ang'ane hii mambo ya uchumi, mambo ya barabara, mambo ya affordable housing, mambo ya universal health coverage. Hata unajua next week atakuwa kaunti hii kuangalia mambo na kulaunch mambo ya affordable housing. Hiyo ndio maneno tunataka tuangalie, aende mbele. Sisi kama jeshi yake ya UDA na Kenya Kwanza tuko nyuma ya rais na tutamuunga mkono mpaka deliver on the manifesto that we sold to Kenyans. Thank you very much.
Mheshimiwa,
agitating for impunity when you say the president should defy court decisions? And then number two,
yes,
is it a case of they are good when they serve you, because they are the same judges? And those
I know where you are going. What I'm saying,
lastly,
yes,
the issue of judicial ombudsman. The same issue was brought up through the handshake.
Yes.
But you guys say it's a bad idea. Now it's a good idea for you.
No, what I can say first is that we look at cases merit by merit. The prima facie cases that are being listened to court. I know many people have argued that when declared, it is a constitutional requirement that when presidential results go, it is the Supreme Court to interpret and validate. So it's not but when they are good or when they are bad. What we are calling out is they are corrupt. And I want to assure you, my brother, this is not, we are not saying, we are not blasting judiciary for the sake of it. Just the way people blast parliament. Just the way people blast. And I have never had an offense where people criticize parliament or executive as an offense. Why is it that when we criticize judiciary, they are not, people take it an offense? They use our money. They use taxpayers' money. Judiciary uses taxpayer money. And that is why you as a Kenyan, you have a right to question what judiciary does. That is what we are just doing. Number three, on the issue of, there was another question, I think I've forgotten the term.
Judicial ombudsman.
The issue is that we are talking about excesses. You know, when executive has an excesses, it is parliament that oversights the executive. Who oversights judiciary? We must have that conversation. And that is why I'm throwing the ball to Kenyans. Let us have that conversation. Who oversights judiciary? Now today, if you have a problem with the executive, you will tell me, Senator Cherargei, can you go take to parliament, call minister in charge of health? I don't want to say another minister. Most people might, for example, if you have a problem with health, you will say call CS of health to come and call a governor. That is, now we can check the excesses of executive. But who checks the excesses of judiciary? Are they good? Can they operate in a vacuum? Can they behave? You know what we call judicial corruption and impunity. Can we allow them? But Article 159 says judicial authority comes from the people. And that is why we are telling the people, you are the one giving money to judiciary, you must oversight the same judiciary. And this judiciary for now has gone wrong. Until they come back, they have gone wrong.
Then there is a process of removing judges.
Yeah, in fact,
corruption. Are there cases you guys are thinking of forwarding to the Judicial Service Commission?
But what I can say, there is a famous case of judicial Judge Temple, that was removed through. I'm aware, and of course, EACC and other investigative agencies are on this matter. There are many judges that have been accused before of corruption allegations. We hope those cases will be expedited. You know, now in principle of separation of powers, DCI and EACC are independent bodies that should carry their job. We are aware there are many judicial officers, but you know the biggest impediment has been the Judicial Service Commission, because they shield some of the corrupt judicial officers and the judges. So that's why we are calling out that as GAC, they must take the lead and allow some of the judges to be investigated so that you can initiate the removal through a tribunal that is constituted under the Constitution.
They endorsed the removal of 10.
They endorse, yes, but we are saying there are many more. It is, you know, when you remove only one and the entire circle is rotten, then we have a problem. And that is why in 2 or 3 President Kibaki used what we call radical judicial reforms. I think it is the high time that we must do it now.
Swali langu ndani ni kama ameuliza, lakini tungependa kusisitizia hapo. Kipindi kile Rais Uhuru Kenyatta alikuwa mamlakani, kesi zake ziliporomoka jinsi nyingi ambazo tunaona zimesimamishwa na mahakama. Hauoni kwamba kipindi kile ilikuwa ina wafeva, hamukuwa na tatizo? Hivi sasa wamesimamisha baadhi za kesi ambayo inalenga miradi ya serikali, unaona kwamba kidogo haiwafevi, ndio maana mnalalama?
Sijui hiyo Kiswahili fevi, lakini labda ni Kiswahili mpya ama inapendelea, sijui wanasema kupendelea. Ya kwamba mimi unajua zaidi ya project zaidi ya 300 billion ilikuwa imesimamishwa na mahakama wakati ule. Mimi ni sisemi ya kwamba mahakama, what I can say, let me say it in English. Sababu Kiswahili inachanganya kidogo, so that it is clear. Let me say in English. We are not saying judiciary should rule in favor of anybody. What we are saying is judiciary must be sensitive and rule as per the constitution and rule as per the... That is what we are saying. You know that...